Good morning, everybody. My name is Raquel Black. I am the co-working manager for Change Labs. I'm Kia'ani, born for Senjikinen. My Chays are Ashinhit and my Nallies are Torajini. Torajini. Thank you all for taking the time to be here with us. First off, I'd like to give a brief introduction to Change Labs for those of you who aren't already familiar with our organization. And then I'll hand it over to Gabriella and everybody else at ASU Law. Officially, Change Labs is a Native-led and Native-controlled nonprofit organization based on the Navajo and Hopi nations. Here at Change Labs, our goal and mission is to provide creative workspace and tools and resources and knowledge for Native entrepreneurs. How we accomplish our goal and our mission is through different programs. Our co-working program, our business incubator program, and our kinship blending program. We have another program that's really, really exciting. It's currently in the planning stages, and we will be able to announce those details at a later time. To start off, I would like to talk about the co-working program, which is the program that I oversee. Now, for those of you who are in or near Tuba City, Arizona, you may have been aware of our co-working space over at the Moenkopi Legacy Inn campus for the past few years. That space is no longer open, which is a picture here. But the construction is currently underway on our new headquarters, which is located right next to Tuba City Chapter House on Main Street. For those of you who may not be familiar with what a co-working space is, it is a community space for business owners and entrepreneurs to help with operating and managing your business. This space in particular will serve our Native entrepreneurs and small business owners, especially those based on the Navajo and Hopi nations in the Four Corners area. So starting as early as 2023 in spring, we will have a brand new co-working space available for you to use. And some of the services that we'll be able to offer are some tools that could be useful to your business. Tools such as desk-based, Wi-Fi access, color printing, in-person coaching sessions, and a lot more. We also plan to bring back in-person monthly trainings for those of you who are interested. And our list of co-working services is constantly being updated as far as how we support our local entrepreneurs and business owners there at the new headquarters. And we are always open to new ideas on how we can better service our local communities. So if you have an idea on how this co-working space can benefit your business, you definitely let us know. We're really excited to bring this community space for everyone and to help with building and growing your business. So stay tuned for more information to come as our construction gets closer and closer to completion. One of our most popular questions we get here at Change Labs is, how do I start a business? All of our programs and services here, including the co-working space, are designed to help Native entrepreneurs and artisans, our local vendors, and those who we like to call change makers, because that's what our local business owners and entrepreneurs are, change makers. They're absolutely crucial to our local economies, and Change Labs is here to help with both starting up and strengthening your businesses. Now, for a brief overview of the Business Incubator Program, it is one of the only Native-led business incubators for Native entrepreneurs in this country, and we're right here on the Navajo Nation, on the border of the Hopi Nation. This program is led by our Director of Business Incubation, Cecilia So, and starting in 2023, it will be a 6-month program for Native entrepreneurs who want support and training on how to start and operate your business. If you're interested and would like assistance with things like your logo, your website design, or how to set up and maintain your bookkeeping and finances, please visit our website for more information here at nativestartup.org/incubator. And then another important note about our incubator program is that we are now accepting applications for the next round of cohort members and entrepreneurs who want to participate in this program for next year's cohort. So if you're interested and if you would like some more information on how you or someone you know may be interested and can apply, please see our website for more information at nativestartup.org/events. Change Labs hosted a live info session with Director Cecilia So, as you can see here in the picture here, a couple of weeks ago. And we do have that recording available for you to watch if you'd like. Cecilia gave an overview of the program. She discussed things like eligibility, the selection process, and she shared things on what we look for in a candidate. Cecilia also shared other resources you can access if you're not yet ready to apply. Another question we get often is, how do I get help running my business? There are so many aspects to being an entrepreneur, and the answer or solution that you may be looking for may not always be obvious. Here at Change Labs, one of our driving factors is kinship, building relationships among our communities and our nations. And how Change Lab can help there is through our business coaching appointments, which is also under the co-working program that I manage. We offer free virtual 90-minute appointments with any of our business coaches. Our coaches are available on Mondays from 11 a.m. to 5 p.m., and they each have their own area of expertise, depending on the kind of support you're looking for. We have a team of very bright and very eager coaches, such as Jessica Stego, our director, our soon-to-be director of the Venture Capital Program, which I wasn't supposed to announce yet. Christine Laughter, the director of our Kinship Lending Program, our finance director, Marsha Greyeyes, and a few more of our coaches are Tim Deal, Joe Elliott-Nez, and then we have Holly Patterson, who's a new addition. We also have Cecilia, of course, who's the director of our incubator program. They are each incredibly knowledgeable in their specialties and will be able to assist you with where you are needing help in your business. They are able to assist you in areas from marketing to accounting and bookkeeping systems, or if you're just starting out, they can assist you with creating a business model and navigating the Navajo Nation system for things such as your business site lease or registering with the Navajo Nation Business Regulatory. You can find information or book your appointment with any one of them at the link here at nativestartup.org/events. And then another common question we get here at Change Labs is, how do I create a website? Until Change Labs can go back to hosting open studio hours at our headquarters in Tuba City, I will refer you to our YouTube channel. We currently have over 40 recorded sessions and discussions, each designed for Native business owners and all led by Native entrepreneurs and Native creatives. Our workshops have covered topics like social media marketing, website design, doing business on the Navajo Nation, and a lot more. It's a growing archive of shared knowledge from other Natives who really want to see our Native people and their businesses thrive. To access any of our past sessions, and including this one after we're done here, and our listing of resources such as grants and other informational events, I'll refer you to our link here, nativestartup.org/resources. We update this page pretty regularly, so be sure to check in every now and then for upcoming opportunities. Another great resource we have are our social media platforms. We are on Facebook, Instagram, LinkedIn, and Twitter. And then we also have our YouTube channel. I do recommend you check those out for our regular postings and updates as well. Change Labs likes to share posts and from others in our networks and our partners for when they're advertising opportunities and resources that are useful to our Native entrepreneurs, our business owners, and our Native creatives. There's a whole spectrum of who are considered Native entrepreneurs, and we here at Change Labs have been curating our own list of them. If you're in the market for finding other Native service providers who can help you with your business, we currently have over 600 Native-owned businesses listed on this site here that we think are really, really great resources for helping to start up and run your business. Or if you're searching for some Native-made products, visit the site here at resrising.org. And if you're a Native business owner yourself or entrepreneur and you have services or products that you would like to promote, feel free to add yourself to the listing here. It's free to add yourself, and it's a really simple process. All right, so if you have any questions about Change Labs in general, or if you're interested in any of our services and would like to know where to start, feel free to email me. My direct email is here, raquel@nativestartup.org. And then now before we start with our guest speakers for today, I want to touch base on workshop etiquette and how we can be respectful of their time today. We do ask that you stay on mute during the presentation unless you're called on, or if you want to raise your hand and emoji, feel free to do that. Or you can populate the populate the chat box with your questions, and we'll make sure to get to them before the end of the session today. And then one last reminder, our session is being recorded today and will be available on our YouTube channel later this week. And now introducing 4 guests today. I'm sorry, I didn't put Alexis's name on here. We have Gabriella, Leah, Trevor, and Alexis joining us from ASU Law. Thank you all for being here. They're here to talk to us about intellectual property, and their laws. And I'm sure that we can go for longer than 90 minutes to talk about all of that, but they're going to give us a brief introduction today and answer any questions that we have for them. So thank you all for being here. I'm going to turn it over to you.
Good. Hi, I'm Gabriella. As you can see my photo there, I don't know if anyone can see me because the slide is sharing, but I'll just give a quick introduction of myself. I'm a third year at Arizona Law, and I'm studying patent law and trademark law. And so that's a little bit about me. I don't know if Trevor and Leah, if you guys want to introduce yourselves as well.
My name's Leah. I'm a second year. I have a bachelor's degree in animal sciences, and I'm interested in potentially pursuing a career in patent prosecution or maybe becoming a patent examiner.
And I'm Trevor. I am also a second year at ASU Law, and I am looking into or wanting to go into patent prosecution as well. So
perfect. So we are all in the clinic. Okay, so yeah, we're just gonna do a quick brief introduction on IP law. I don't think it'll take 90 minutes, but we are going to welcome any sort of questions and things like that. We tried to make it a little interactive, so hopefully that's nice. Okay. So just an outline of what we're going to be talking about today. And I just want to confirm everyone can hear me. Yeah. Okay, cool. We're going to be talking about like what the clinic itself is and like what we do in the clinic, what is intellectual property, and then what is IP law and what should innovators do to protect their IPs. So just in general, people who have businesses or things like that want to protect their rights. And that's what we do, is to make sure you get those rights. Okay. So the Lisa Foundation Patent Clinic, the clinic is a part of the law school, and it's one of the many that they have, but it is the only one that does any sort of intellectual property rights, so patent and trademark. And students, so like myself, Leah, and Trevor, we work with individual business owners or companies, things like that, startups, and we file their applications and we hopefully get their rights. So whether that's a trademark or a patent, we help by like searching to see if there's anything out there that's already similar to that. And then if there's not, we kind of go through the process of filing that, like creating the application, filing it. And then we also help with what's called like trademark prosecution or patent prosecution, which is if that initial filing of the trademark or patent receives some sort of rejection, we help with arguing against that rejection. So we help all the way until there is some sort of trademark or patent protection. We don't help with enforcing those after the fact, but that's what the clinic does. And so there are 4 types of intellectual property. There's patents, trademarks, copyrights, and trade secrets. And Leah, Trevor, and I all can do patent law, which is awesome. To do patent law, you usually need some sort of technical background. And so I guess I didn't mention that earlier, but my background is chemistry, Trevor's is chemical engineering, and Leah has animal sciences. So we're all able to practice with patent law, which is awesome. And then trademarks, you don't need any sort of background to file those applications, copyrights, trade secrets. And we're going to get a little bit more into those and what they are and what the different rights are that you get with each one.
All right. So this first slide just kind of shows maybe some funnier examples of patents. A lot of times when people think of patents, they might think of something more serious and sophisticated, but patents can range from those very sophisticated items to things that are really completely random and kind of silly, honestly. So patent law it's a federal law with roots in the Constitution. And what a patent actually is the right to exclude others from making, using, selling, offering for sale, or importing goods into the United States that have a patent on them. There are 3 main types of patents, and those are utility, design, and plant patents. And there are limited patent terms. So utility patents generally provide the patentee protection for 20 years from the filing date of the earliest application, including provisional applications, which can be filed in place. They're kind of like a placeholder application for a non-provisional application that actually gets examined by the patent office. Design patents are valid for 14 years from the issue date of the application, and plant patents have protection for 20 years from the filing date.
And I also just wanted to add that it's really important that if you are trying to get a patent, you know that it's the right to exclude. It's not a positive right. So if you get a patent you don't have the right to make, use, sell, or offer for sale. You can license it or something along those lines, but you can't actually do it, which is kind of a weird concept, but it's just how it is. And so it's important to kind of know that distinction.
This is a cover sheet for a patent. I don't know if many of you guys have ever seen one before, but this is what they all look like. They have the patent number and the date of issuance in the top right corner. The last name of the person who has filed the application, usually the inventor, is on the top left under the words United States Patent. There's some other information on this page, and there pretty much always is a figure that has been submitted with the application shown on this cover page as well. Novel is defined as the claimed subject matter is new and not previously known before filing. Useful is defined as the invention must yield utility that is specific and substantial. And there are specific things that are known as patentable subject matter. And there are four really. There's process, machine, manufacture, and composition of matter. And so a process defines actions and an invention that is claimed as an act or a step or a series of acts or steps. A machine is a concrete thing consisting of parts or of certain devices and combination of devices. Manufacture talks about tangible articles that are given a new form, quality, property, or combination through man-made or artificial means. And composition of matter is a combination of two or more substances and includes all composite articles.
Right. And I just want to add, like, what does this mean of like, what is patentable subject matter? That basically means if you're going in to try to patent something, it needs to be one of these four things. Currently, one of the big things that people are trying to patent is software, but software doesn't really, like a code or something, doesn't really fall into these four categories. So it's a lot harder to patent because you have to somehow apply it to make it something that's patentable. And we will get into copyright, but sometimes it's easier to get a copyright on a code than it would be to patent the code. So that's just what we're talking about here. So all the things that your patent needs to be in order to get a patent is just something that's new, useful, and then it has to be one of these four things.
So these are just some examples of patentable inventions. The list, can go on forever, but things like pencils, hammers, light bulbs, drought-tolerant corn, as opposed to corn that grows naturally, something that has been changed in some way by humans, drugs, medical devices, and medical procedures. So design patents are different from utility patents in that they protect the ornamental design of an item as opposed to the utility of the item itself. An object with a design that is substantially similar to the design claimed in a design patent cannot be made, used, copied, or imported into the United States. And the copy does not have to be exact for the patent to be infringed. It only has to be substantially similar. And these are also some examples of potential things that could be covered by design patents, like fonts, this curvy 1915 Coca-Cola bottle, the Statue of Liberty, something iconic to our nation, an ornamental design of jewelry. And these are also some cost breakdowns for filing and things like that. So for the government filing fee, you're looking around $250 to $2,000 for filing an application. Drawing fees, commissioning an artist to give you your drawings is usually around $500. Attorney fees can range, but you're looking at $1,200 to $3,000. And so your total is usually around $1,950 to $5,500.
And I just want to add that the clinic is free. So if you do have a utility patent, design patent, or some sort of trademark that you are looking to get some protection on, we do that for free. So you can at least save around $1,200 to $3,000. Of course, the actual filings and fees are not something we pay for, but it does save a lot of money. And so we've done a lot of cool things in the clinic.
So these are just some time periods that you might want to expect if you're filing an application. It is usually a pretty lengthy process. So in order to get a first office action from the USPTO, meaning like the first contact that they'll make with you after taking a look at your application, you're looking around a little bit over 2 years, 24.2 months on average. And it usually takes an average of 34.5 months to get from beginning to end on your application. So again, that's around almost 3 years that you're looking at from start to finish. So like I said, it can be a pretty lengthy process to go through. So this is just a summary of points. Patent law protects novel and useful inventions. A patent is a monopoly for a limited term. And when you're looking to file an application, you should probably think about, if you're talking to other people about your invention, you should consider using non-disclosure agreements if possible. And definitely get your application in as soon as you possibly can.
And then we will just take a second if anyone has any questions on like patent law in particular. If not, we'll go towards trademark. I don't see any questions, but if something pops up, let me know. And so now we're going to go into trademarks, and this is kind of a fun little thing I put. You guys can participate if you want, but I just put very common designs on here, and I imagine everyone instantly recognized all of these.
Oh, we got a question.
Yes, and one of us can put our emails in, and then you can email us and we can send you the form to apply to the clinic. You know, when you see these trademarks, you instantly know that's Google, Twitter, Apple, Nike, McDonald's, Starbucks, Pepsi, Chanel, Target. And that's the really cool thing about a trademark, is that it's a company's way of identifying their sourcing goods with consumers. And so that's just a little fun thing. Without even knowing words, you knew what those marks were.
Trademarks are able to be filed under both federal and state law, which makes them a little bit more unique not in a different way compared to patents, which are an entirely federal law. So with trademarks, they are not something that protects an actual thing, whereas it is more so the brand or the recognition that it's going to be protecting. So a trademark is going to be protecting words, names, symbols, sounds, or colors that distinguish the goods and the services from those that are manufactured or sold by others, and it indicates the source of them. So a trademark is used primarily to be able to protect source identification, so that we can make sure that consumers know where these goods are coming from. So if you're going to be buying a Coca-Cola, you want to make sure that Coca-Cola is produced by the Coca-Cola brand, as well as preserving goodwill, because let's say that Coca-Cola that you bought was a knockoff and it tastes absolutely terrible. That's going to be representative of Coca-Cola because you thought it was from them. So it's going to also preserve the goodwill of Coca-Cola themselves and protect them from having a bad reputation. The trademarks, unlike patents, they can be renewed indefinitely. So it can last as long as you continually use it. And that's the main, key factor that you need to have in there, is that your mark is being used in commerce, which means that you're actually using it to make sales of things, or if you're a nonprofit, you're actually using it to gain donations and give those donations to someone, or something along those lines. Which, if anyone needs further clarification on what being used in commerce means, please let me know. The registration of the mark is based on, here we're going to be talking about federal registration. State registration is its own thing, and we're not going to be talking about that here, but the federal registration is through the USPTO, just like patents, and it has a slightly different process, but it's still quite similar.
Right, and our clinic only registers through the USPTO, so that's why we know more about that. And it's, in general, it probably gives you broader protection, and the only reason you would want state protection is if you're not using it in other states, I guess, if you just want protection in your state. So
there's two types, and those are standard character or word marks, and then stylized or design marks. The standard character ones, they can register words, letters, numbers, or any combination. It's not what the mark looks like. It is the actual content of the word or the characters, what's in there, just as it says. So you don't have any claim to the font, the size, the color, or any design element of it. Whereas with the stylized or design format, you're going to have all of those things, really. You can have a word in your design mark and you're claiming the specific look of that word. There could be a picture alongside that, or as we saw earlier, it could be the little bird from Twitter or the Target for the Target stores. So It's the actual appearance of the mark that is protected through a design mark. And these are two separate things. So if you have a brand like Twitter, if you want to protect Twitter, you have to do the logo and a separate word mark or standard character mark that will carry the word Twitter as well as the little bird. And so they can't be mixed into one.
Right. And in the USPTO, just quickly, it's $250 per application or, class. So it can add up, but it's not the priciest thing to get a trademark either.
Right. So the process of getting through there and actually getting your trademark is following through with a search first, because we can't have a mark on something that's already registered. So what we do in the clinic is we go through and we do a search and we try and find if this mark has already been used or has it already been registered. And so if it's being used already, then that's something that's going to be barring you from getting that, because it's going to cause a likelihood of confusion, which I will talk about in a little bit. We don't want to have confusion among different brands within the same field of commerce, because we won't know who is selling what. It'll cause issues down the line. And so the USPTO has a website for us to be able to search for trademarks. When we are doing it within the clinic, we spend a good amount of time trying to find anything that could be preventing one of our clients from getting their mark registered. And then we'll be able to give you guys a patentability, or it's not a patentability, but a registrability opinion. And this is something that can be accessed by anyone. Tests can be searched and you can search through anything. Just type in any mark or any word that you want to see if it's there. They also have keys to be able to search through designs as well, which is a little bit more complicated, but they do give you a pretty good explanation of that. After the search is performed, a application needs to be put together. So you have to draft the description of the goods and services, and it needs to be specific enough to identify the nature of the goods and services. But the level of that specificity is going to depend on the type. And so something that goes into trying to get these is trying to make sure that we can give you as much coverage as possible and not be so overly specific that we end up narrowing your scope of protection to just really, really small, one specific object. We want to make sure that we can protect you and your brand as much as possible. So we don't want to go too specific, but we also don't want to go too broad, because then we can end up having to continually narrow that. And then we file that application at the USPTO, and there's two main types, and that's intent to use or use-based. And as I said earlier, with it needing to be used in commerce, this is where we have that come in. So if it's not currently being used in commerce, but you think it's going to be, you can file it as an intent to use. And that will give you a 6-month window to be able to file a specimen of use, and just evidence showing that you are actually using your mark in commerce. And that can be extended up to 5 times, but each time that happens, you need to pay is it $125 for an extension? Mm-hmm. And so one way of avoiding that fee is just by filing as a use-based. And so if you already have your mark being used in commerce, then you can just go and say, hey, here's my evidence of it being used, and they will allow you to file.
Right. And I just wanted to add, when Trevor was talking about what the description is, and it depends on how specific it is for each class, it's an example of coffee is completely acceptable. You don't have to specify coffee beans or ground coffee. You can just say coffee. But if you have an accessory, it's like, well, what is that? A watch accessory, a hair accessory? So that's when you have to be a little more specific. And like some classes themselves might even be more specific than that. And that's just what he was talking about with that. So as he said, we do try to be as broad as possible to get you the most protection, but sometimes you have to specify just based on it being too broad.
So some of the things after we submit the application that can come back and cause us to not be able to get it, or that would bar it just from the get-go if we can find anything, are deceptive marks, which let's say that you are, right off the top of my head, I'm trying to think of one. Let's say that you sell clothes or exclusively winter jackets, and you call your company shirts and shorts. It's deceptive that you're not selling shirts and shorts. And so it's going to cause consumers to think, oh, this is a brand I can go to be able to find shirts or shorts, but they only have winter coats. So that's going to be something that would be considered deceptive, and we don't want to deceive consumers. A false association is if it's going to be associating your mark to something that it is not associated with that could harm that other thing. We don't want that to be happening. There's also likelihood of confusion, which is one of the main ones that we run into. And so anytime that your specific mark could be confused with another mark that's already in use, there's going to be a likelihood of confusion, rejection that or bar that comes up, and will prevent you from being able to get that mark registered unless there is a very good argument that can be put in and submitted to the examiner to be able to convince them that yours is registerable and it's not going to be in conflict with this other mark. Geographic terms are also not something that we want to have in there, because if it doesn't actually come from that region, then it will be barred, because it can be deceptive. And we also have surnames. We don't want to allow people to get a mark on a last name, that especially ones that are popular, because then that'll prevent people from ever being able to use their last name. And that's something that we don't want to do. And then functionality, marks are just marks. They're just the word. We don't get any protection of functionality through a trademark. Examination is very similar to the patents. Once you file it, it will go to an examiner and they will determine if it should be issued or not. And a rejection from the USPTO could come back, and that would be either a standard refusal or a final refusal. Either way, it can be appealed, and you just have to pay a fee for that, and you can keep fighting to try and get your mark. Before you issue your mark and after examiner approves it, it has to be published for opposition. And so this allows other parties to be able to come in and say, hold up, this is going to pose a problem. This could be too similar to my mark. This could cause bad reputation for us. And so it gives them an opportunity to come in and raise opposition to the registration of your mark. But after you pass that time period, I think, is it 30 days?
Yes.
Okay, after the 30 days passes, and you get your certificate of registration, you will be able to use the registered symbol, which is the little circle with the R in it. And that gives everyone notice of your registration. And you want to be using that because that's going to give notice to people. And if people are starting to use your mark, they can argue that they did not have notice that yours was registered, and that could potentially prevent you from getting profits or damages if you do sue to stop them from infringing on your mark. And then on top of that, you need to make sure that you're continually using your mark in commerce. And so periodically you have to file specific maintenance documents that'll keep it alive. And that's one of the things that will make sure that your mark stays live forever. As long as you're able to continue to do that and you continue to use it in commerce, your mark will never die.
And I just wanted to add, with the opposition, it's not that common unless your mark is similar to a very large company. So if you happen to have a trademark that you're trying to get protection on, and it's somewhat similar to like a Nike type trademark, they have attorneys that monitor the Gazette every time it's posted. So like that may not go through, but if it's really not similar, this isn't something that comes up that often. It's mostly just with big companies that have the resources to be checking this thing for opposition. And then also with use in commerce, to maintain your application, you're technically always supposed to be using it in commerce, but there are a few grace periods. So, when the pandemic hit, if people weren't using their mark in commerce during that time, you could just write something and say, hey, like in good faith, I wasn't using it. I didn't abandon it. It's just like the circumstances. So there are a few ways to kind of extend the period without having to abandon your mark?
So overall, we are just with trademarks, we're looking at how it protects marks that are associated with goods and services, and they help us to identify the source of the goods and services. And it's a protection for both the consumer as well as the owner of the mark. Make sure that you're using your notice of registration once you get your mark so that you can protect yourself even further. And then make sure that you're continually using it in commerce and filing the appropriate documentation when the time comes to be able to maintain that mark. Does anyone have any questions about trademarks?
Think we're good. Of course, you can always ask later. And we know that trademark has a lot of information. It just tends to be the ones that people want the most or can get. And so we just wanted to make sure that that was thoroughly covered, because it seems like a lot of people tend to have access or like need some sort of trademark protection. And we're going to move into copyright, but Alexis wasn't here earlier with the introduction. So she's going to introduce herself and just say like what year she is and all of that and what kind of law she's doing in the clinic. So.
Hi, everyone. My name is Alexis, and I'm actually a 3L at ASU Law. And right now in the clinic, I am primarily working on trademarks. So I do not work on any of the patent part, just because when I was in college, I didn't take any science courses. I don't have any science background. And so I cannot take the patent bar to file patent applications. So I really just work on the trademark stuff. And so far, I really like it. But today we're going to be talking about copyright. So what is copyright law? So first, it's grounded in the U.S. Constitution. And a copyright is a form of legal protection that is provided by the U.S. for authors and creators of the original work of authorship that are fixed in a tangible medium of expression. So when a work is fixed, it means that it has secured automatic protection. And the types of works that are copyrighted are usually literary works, theatrical works, musical works, artistic works, audiovisual, and architectural works. And this list is not limited. So original and fixed. So what does originality mean? What does fixed mean? So when you're looking at originality, you also have to look at creativity. And to be original, an author must create the work independently, and the work must exhibit a minimal degree of creativity. Next, fixed. So when a work is fixed, it can be perceived longer than just a transitionary duration. Additionally, as an example of this is the Feist case. So here, the thing that was allowed to be copyrighted was an arrangement of telephone numbers and addresses in a phone book, but not the actual directory. That was not allowed to be copyrighted. So copyright registration, you don't need to register your copyright register your work in order to secure copyright. So prerequisites for copyright protection is that the work is not functional. You cannot protect an idea, but you can protect an expression. And the work needs to be original. So for example, the Harry Potter series by J.K. Rowling. So you can't take her exact expressions and what she exactly wrote in the book, but you can write a book on a boy who went to a wizard school. You can use that idea. So why register? If someone does steal or copy your work, you need a registration in order to file an infringement suit in court. And registration just also establishes a public record of your copyright claim as well. Here are some other factors that affect copyright terms. So when the work was created, published, or registered, if the work was created by more than one individual, and if the work was created by an employee of a company that is claiming the copyright.
Right. And it's super important to know, like, if you are trying to do a copyright, that employee prong at the very bottom is very important, because it does, if an employee did it at work, that's the company's copyright. But if the employee did it outside of the scope of work, not for work, it's probably not, even if it was like somehow related to the company. So it's really important that if you do have a company and you have employees that are making works that could be copyrightable, that you would be putting very specific guidelines in place so that nothing gets lost in translation, and like either the company or the employee doesn't lose their own copyright based on that.
So next, more copyright terms. So for works created by one author on or after January 1st, 1978, copyright protection begins at the moment of creation and lasts for 70 years after the author's death. And then in a case of a joint work, which a joint work is just a work that was prepared by two or more authors, the term lasts for 7 years after the last surviving author's death. And then lastly, works made for hire and anonymous works and pseudonymous works. Copyright protection will last for 95 years from publication or 125 years from creation. So they'll just go off the time period that's shorter. So lastly, just a summary of copyright law. Copyright law protects expressions of original work, and copyright is to secure a work when it is fixated, but you need a registration to enforce the copyright in court. Does anyone have any questions?
Hi,
Okay.
I have a question. My name is Brenda. I wanted to ask, if you work for an organization and you create a body of work and they don't tell you they're going to copyright it, is that okay? Or is copyright like is something it's something that we create under the organization name and then they own it?
So, you go ahead.
I was just gonna say, it really depends, like, did you make that body of work at work for something related to work? Then it's probably the company's. If you painted an art, like a piece of art at home and it's irrelevant to the work, then that's yours. But most of the time, it tends to be the company's copyright, even if they didn't say they were going to copyright it. And what that really ends up meaning is that even if it's the company's, that basically just means that even though you created it, you can't just go and sell that because it's not yours to sell, it's the company's.
Okay, what if they didn't compensate you for your time and effort?
I don't believe, I think that if I can look a little deeper into it, but as far as I know, if you made it at work and it was for work, they wouldn't have to unless you're an independent contractor, they don't have to specifically compensate you for that piece.
When it comes to those things, I believe that it all depends on the contract that you have written and what were the terms of that contract. And if you didn't have a contract, I'm not totally sure if it will be enforceable or not. So
Okay, yeah, it was an independent I was working as an independent contractor. There was no contract about it, but I made the material and then they used it and they put it into their notebook without letting me know that they were copywriting it. So there was no actual discussion of that. That's why I was asking.
I am looking, and
I think the question is, was it created within the scope of employment at that point?
That is the main question, as far as I know, that usually
Right.
is raised as scope of employment.
Right. I'm trying to find the particular factors. I know it's a little different if you were an independent contractor, because an independent contractor is obviously not working there full time. But I know that if you were hired by them to create this piece of art, it is theirs. As if it was within the scope, like if that was kind of what the expectation was, then it should be their copyright.
Yeah, and unfortunately, if that is the case, I don't think that they have to give you notice that they're going to be using it or how they're going to be using it.
Right. And as Alexis said, it would definitely be worth looking into the particular contract of that. But I do, from my understanding from intellectual property, and it kind of seems like everyone else's, there's a case that has 13 factors to consider when you're thinking, like, was there an employment relationship? And one of the biggest things is, like, if you were hired to make that thing and you made that thing, you gave it to them, it is theirs. And compensation is a factor towards it being theirs, but it's not dispositive. They may not have had to pay you if there was some sort of agreement otherwise.
Okay, thank you. The 13 factors to consider. Did you guys go over that, or will I be able to see that? I came in late. I apologize.
No, I didn't put them in this slide. I can read them off my notes, and then I can also send those in a document after, but it's just this court case where it's called Community for Creative Nonviolence versus Reed. And Reed's work was not for hire because he was an independent contractor. He supplied his own tools, worked in his studio. He was retained for less than 2 months. He didn't do any other work, and he had a lot of control over how he decided to work. And so then the factors are basically the hiring party's right to control the manner and means by which the product is accomplished. So with this company that you were working with, if they controlled your day-to-day work, then like it looks like it's more their work than your work. If you had to have a special skill, that might be they might have hired you for the skill, the source of instrumentalities and tools. If you painted something, did you use your own canvas and your brushes? The location, did you do it at their work or were you at home doing it? What was the relationship between the parties? Did the hiring party have the right to assign additional projects, or was it just that one project? The extent of the hiring party's discretion over when and how long to work. So like I said, if they have control to say, hey, you need to work 8 hours Monday through Wednesday, they're controlling your schedule. But if you were independent and they just said, get it back to us in 3 months, then you have a little more flexibility. It might not be their copyright. There's the method of payment. Like I said, this is one factor. It's not dispositive, but payment can be more if they paid you, which you said they didn't, that no payment tends to lean more in your favor than it would in theirs. If you have the ability to hire assistants or not, the more flexibility you are given, the more likely it is your work over theirs. And then do they constantly hire you to do these types of projects? If they are constantly hiring you to do similar projects, it's probably theirs. Whether the hiring party is in business, and then they're like, what were the employee benefits? Were there any? This is kind of what Alexis was saying. What is the contract specifically? And then what was the tax treatment of the hired party? Did the company have to pay tax on you like an employee or an independent contractor? So those, I can send Raquel some sort of like just the court case and this is all, this would be state court stuff that if you sued them, these are the factors they would be looking at. And realistically, that's the only way you can get protection on this copyright is to sue and, go through all these factors. But I can definitely send like a little summary of that.
Cool. That would be very, very helpful. Can I just put my email in the chat?
Yes. Yeah. And then did someone send their email to Jeff?
I can send my email to Jeff.
Okay, great. So Leah will email you with how to get started in the clinic for that design patent. And then Brenda, I will email you with that information.
If you could just drop your email in the chat box, Jeff, that would be great.
And then I'm going to talk a little bit about trade secret now. Trade secrets are not something you can really, actively get protection for. You just kind of, you have your trade secret. And if someone were to somehow get that, that's when you can kind of get action on it. Otherwise, it's a secret. So, you just have it, and that's that. But it's all under state law. There's the Uniform Trade Secret Act and the Defend Trade Secret Act. So those are two of the main ways that all the law is set out to know what a trade secret is and how to protect it and those things. And to have a trade secret, it has two requirements. The information has to have economic value, and you need to actively do things to protect that information. And so economic value, that just means like, are you a company making money off this particular thing? And then, keeping things secret, confidentiality agreements, or instead of having if you're Coca-Cola and you make that syrup, instead of making the syrup in an all glass building, like it probably needs to be cement so people can't look in. Any sort of security is the type of thing you're doing to keep a secret for your trade secret. And so there's not really much more to trade secret law than that, because as I said, it really comes more into play when you're trying to enforce it, that someone infringed on your trade secret. But to actually protect it, it's kind of just, you have the right until someone steals it. But I put up a little slide here with some trade secrets that you might know. So Coca-Cola, the syrup to make Coca-Cola is a trade secret. No one knows the exact ratios and ingredients in it. Obviously, there's things like Pepsi or like store brand Coca-Cola that tastes like Coca-Cola. So people have come close to doing that, but the actual recipe itself is a secret, and it does derive economic value. The seasoning for Kentucky Fried Chicken, that's another thing that is a trade secret, or like the Big Mac sauce on a Big Mac. And then Google, like their search engine, the way that the algorithm works is another trade secret. So that's just a little bit on trade secret. It's not something that a general IP course covers too much, just kind of a quick introduction, because even though it is an intellectual property right, obviously like the syrup to make Coca-Cola is very complex chemistry. And so like there is like this intellectual property right that should be protected, but in general, it's not really protected until afterwards. So it kind of leans away from that. But other than that, those were the 4 things we had. This is my email. So if that's helpful to anyone, you can always email me. And then I guess Trevor and Alexis, if you just want to throw your emails in the chat. I know Leah, or I guess Leah didn't, but you guys can always email me. And then Professor Gross is our clinic director for now. So you can email her as well if you wanted to get in touch with the clinic beyond us. But I know that Jeff, we will email you the form to sign to get into the clinic. So that's kind of that. That's just the quick, brief introduction on intellectual property law. If anyone has any questions, we will answer those now. Oh,
Do we want to give a quick overview of the Indian Arts and Crafts Act?
yeah, we can do that. So I just kind of learned a little bit about it. We didn't, we've never, we've never like touched on this in class or anything, but the Indian Arts and Crafts Act is basically something that prohibits misrepresentation and marketing of Indian art and craft products within the United States. So it's basically illegal to offer or display for sale or sell any craft or craft product in a manner that falsely suggests it's Indian produced or an Indian product or a product of like an Indian tribe, native tribe, that kind of thing. This is what Trevor was talking about earlier with the Coca-Cola. It's, for example, this is obviously a less severe example, but if I walked into a restaurant and it said Coca-Cola served, and I got my Coca-Cola and then like I tasted it and I was like, this doesn't seem right, to find out that they lied about it. This is the same thing, but it's obviously on a much higher scale, because now we're talking about Indian tribes and arts and crafts, which is obviously very important to protect that culture. So it's basically saying if I went to a farmer's market and I saw a booth that said Indian jewelry, to sell it, saying it's Indian jewelry has to be from a tribe. It has to be either from like a tribe or
Like someone that is actually Native American and like registered under a tribe, has that heritage. You can't be misrepresenting that the person that made it was Native American when they weren't.
And so there are fines for this if you do this, because it's illegal. So for a first-time violation, an individual can face civil or criminal penalties up to $250,000 for a 5-year prison term. You could do one or the other. And then if you keep doing it, the fine goes up. So it's really important to not misrepresent any sort of goods that you have. And then
that goes even down to the tribe level. So if you are Hopi, but you're saying that you're producing and selling Navajo crafts, you can be misrepresenting what actual tribe it's coming from, and that is also something that can be a violation. So you want to be making sure that you are not misrepresenting even at that level.
Right. And you have to be enrolled in the tribe. So it has to be very official. And just for anyone in general, and I know now I will be looking at this, if I do go to a farmer's market and I see Indian jewelry, I would be very cautious to just actively talk to the person and really inform myself of where that's coming from, obviously, because it is something that they're trying to preserve, the arts and crafts. And so it's important to just like also be aware for yourself.
So this is a lot. So you might have covered it, but I was trying to find it the best I could as I was writing my notes. One thing that happened to me was I'm a nonprofit. I created my own slides to present to the university. And it was a conference, so I put it up. And then 2 weeks later, I found that because I talked about that program and I had it up there, and I stupidly did not put my logo or anything on that slide. Next thing you know, that slide that I was talking about, they used it on their program, saying that professor was talking about this, and that was me. And that was all of my information. And I saw that on there, and they were promoting it that way. Is that, how could I, well, now I have like my logo and stuff on all of the slides, regardless of anything. But I just was like, what the heck? I didn't realize that people in a university or a national program would do something like that. They didn't give me any credit. And they said that it was a professor that presented that slide. I just contacted them and I said, hey, that was my presentation to the person that I knew. And they never got back to me, of course.
I feel like that would fall under more copyright.
Yeah, slides. And I mean, I would have suggested contacting them. And since you already did that and it didn't go super well, I think Trevor's right though. Like the only way to enforce that is through copyright. And because you do have your trademark, but I mean, now you have your trademark, so hopefully that helps. But like in terms of slides and them presenting those, I think that would be a copyright issue.
Yeah, because I made them and everything I did on there was from me, like intellectual property. And I just said that I worked with this program, and then they stole that as I was presenting, which was weird. But it would be copyright because that's, I don't know. This is where we kind of fall into, because on native land, we have all of the stuff that is not written now. And then when you do these presentations, I will not give it to them anymore. I'll say I'll share it myself. And then they try to give me BS and I'll say, no, thank you, because this has happened to me now. Other than really splashing my logo all over the PowerPoint, because, that wasn't cool. And honestly, it was like, you would think that the university would know better. And that program, that's a national wide program. And I'm like, whoa. And then now I feel like it's happening again. Because there was a talk and they alluded to everything that my subject was too, but they never said, all they said was, with these grassroots local programs. That's it. They never mentioned my name. They never mentioned my nonprofit, nothing. But everything that I normally talk about and everything they stole, you know what I mean? They watered it down a bit and they made it into generalization, but they used that. And I was like, what the heck? And this is another national program. So I'm just kind of like, I don't know. So it's copyright. So I just need to be copywriting my slides then, or my content.
So with like your copyright, so you do have protection because you don't need to necessarily register your copyright in order to have protection, but to actually file like a suit against maybe the professor who stole your work and then didn't give you credit for it, you would have to register your PowerPoint slide. So basically what that would look like is like you would go to the copyright office. You can go to like their website. I think it's copyright office.gov or maybe copyright.gov. And you would have to fill out their application, their copyright application. And then you would also submit a form of that work. So maybe you submit like screenshots of your PowerPoint or a PDF of the PowerPoint, and you would have to have that registered under the Copyright Office in order to file any sort of suit against an infringer.
Okay, I think when I'm working more with them that I really need to do that a lot more. I'm a little jaded. I heard about this. I thought it was a bit smarter, or thinking that, again, I think that's just gonna be my caution for everybody else here. Don't trust anybody. Then don't trust national organizations. Don't trust the schools. because that's what I did, and that's why I didn't kind of, I didn't want to be all, I don't know, weird about and tacky putting everything on that slide, because I thought this was all for improvement, but then when they didn't give me any credit, that sucks. So that's all. Thank you.
Yes. And then I was just trying to find information on how do you enforce the Indian Arts and Crafts Act of 1990. I'm not completely sure. I really just learned about this today.
I looked at it and I think that it's pretty closely tied with Fish and Wildlife, actually. I remember learning about a case in one of my classes about, I couldn't tell you when it happened, but there was a person who was selling some sort of jewelry that was traditionally done by Native Americans. And I remember that Fish and Wildlife was who got involved and who was really going after the person who was offering this jewelry for sale. So I think that is who you would probably contact or try to alert.
So hopefully that helps a little bit. We're not too sure. But yeah, does anyone have any other questions?
And I'm not sure about the Fish and Wildlife comment. Native Americans in general, we're under the Department of Interior, so it may be branched under there. So that's where the government classifies us, along with Fish and Wildlife. If there are no questions, yeah. So Roy Katie, thank you for that. He posted a comment to there. If there are no more questions, I will take over. Thank you, Leah, Trevor, Alexis, and Gabriella. I'm sorry I didn't have everybody's headshots on my screen here.
Don't worry about it.
I swear I'm not trying to play favorites.
Gabriella's the most important one anyway.
All right. But thank you all for being here and sharing all that information with us. I see not everyone, but there's a lot of emails that were dropped into the chat box. If anyone wants me to share any of that information with each other, with anyone else who is on the call or not on the call, please let me know and I can get that information dispersed. And then I do have a last couple of remarks. Besides thanking our speakers here, I want to thank our audience members for all of you joining us today and for your questions and your participation. We will have this recording available later this week. We'll just have to send it to our editor and she can get it all finalized, and then we'll post it to our YouTube channel. And we will also share the information on our social media platforms. So Facebook, LinkedIn, whichever platform you're on, we'll have it shared there as well. And if you missed any part of my presentation, you can go ahead and email me as well if you want any more information, or if I talk too fast there in the beginning. I know I'm guilty of that sometimes. Then the last thing I have is our announcement for our next workshop, which is going to be on December 7th, Wednesday again, same time at 11:30 Mountain Time. We'll be featuring TransLab's very own Holly Patterson here. She is one of our new business coaches, and she works for the Business Incubator as well with our director, Cecilia. She will be covering social media basics with TransLabs, not with TransLabs, for the holiday season. She'll be discussing different tools that you as a business owner and entrepreneur can use to market yourself during the season. And then we do have the registration link up on our website at nativestartup.org/events. And I will have that on our Facebook page and other social media platforms as well. So if there aren't any other comments or just questions at all, we will end our session here today. And thank you all for joining us. Have a great day.